This is Duke University.
For those 1Ls in the audience, I bid you a very warm welcome to law school and to Duke. Today's review of important civil decisions of the Supreme Court of the United States during the previous term is sponsored by the program in Public Law. The program fosters better understanding of the public institutions in the United States, of the constitutional powers and limits within which they operate, and of the laws and legal principles that apply to the work of government officials. The program seeks to raise the visibility of public lawyering as an option for law students to pursue at some time in their careers. Within the law school here at Duke, the program in Public Law sponsors or co-sponsors a rich array of activities. They include academic conferences open to the law school and university communities, moot courts in pending cases before the Supreme Court of the United States, such as the one we will be hosting on September 27th in a case named Lozman against City of Rivera Beach. We also host visits to Duke by past and present elected officials, judges, and public lawyers, pro bono public service projects, such as the North Carolina state finals of the We the People high school competition on the Constitution and Bill of Rights, which the program hosted this past spring and will be hosting again in spring of 2013. And finally, we host lunch events such as this one on important issues in public law. The program is supported very generously by one of our alums, Rick Horvitz, of the class of 1978. And I also want to acknowledge the coordinator for our program, Dana Norvell, who makes sure that you folks are fed and that all the panelists are here and taken care of. We could not do what we do without Dana Norvell. So our subject today is important decisions of the U.S. Supreme Court in civil cases, that is to say non-criminal cases, during the October 2011 term. That is the term that ended this past June, on June 28th. Supreme Court terms are named by the date in the October in which they begin. They begin on the first Monday in October, and so on the first Monday in this coming October, please do be on the lookout for a Supreme Court preview during lunch. This last term was an historic term, and this current term is shaping up to be an historic term as well. Joining me today are Professors Margaret Lemos, Ernie Young, Katharine Bartlett, and Joseph Blocher. Professor Lemos will get us started by having a look at the statistics from the October 2011 term and identifying some broad decision-making themes. Then Professor Young will analyze two major decisions of the court during the past term, a case called Hosanna Tabor, which is many have called the most important religious liberty case of the court in several decades, as well as a major preemption decision in Arizona against the United States. Next, Professor Bartlett will examine the court's recent decision in a case called Coleman against Maryland Court of Appeals, and will talk more broadly about the court's past encounters with pregnancy. And finally, Professor Blocher, batting cleanup, will assess some of the court's more important free speech decisions from the term. There were several of them. Now, if you think there's an elephant or two in the room, let me say that we're deferring consideration of the court's June 28th decision in the healthcare cases. There's going to be a lunch event here devoted solely to that decision on Tuesday, September 4th. That event will be co-sponsored by Public Law, the Health Law Society, the American Constitution Society, and the Federalist Society. If you can't help yourselves, we're going to have 15 minutes for Q&A. You can ask questions here, but in our presentations, we're going to focus on some other important decisions that deserve recognition and assessment in their own right. Each of our panelists has assured me that they're going to speak for no more than 10 minutes, which I will enforce with my iPhone, and that will leave us some time at the end for questions and comments from you folks. Professor Lemos.
Okay, let me talk fast. So as Professor Siegel said, I'm just going to give you some stats about the last term to sort of give you some broader perspective about what the court is up to up there. So the court issued a total of 75 decisions in merit cases in the 2011 term, 10 of which were summary reversals. So those are decisions issued after, without any oral argument. They're quicker, often per curiam decisions. So 75 is on the low side of average for the court these days. Over the last 10 years, we've gone from between a high of 86, which still is not that many, and a low of 72. And so the court is not issuing a ton of decisions. As you'd expect, the overwhelming majority of these cases were appeals from the federal circuit courts. 15% were from state courts, and the rest were from circuit courts, with the exception of one from the district court. Most of them were civil cases, which is our topic for today. So 67% of the court's docket last term was civil cases. 13% were criminal, and 20% were habeas cases. Habeas cases are sort of a hybrid of criminal and civil. They are folks who are in prison on criminal charges trying to get out through a civil mechanism. So they're sort of between criminal and civil. The most common kind of legal question last term, and this is common for the court, were questions of statutory interpretation. By my count, which was rough, I will admit, there were at least 20 cases that turned on some question of how to interpret a federal statute. That is not including the habeas cases, which are themselves often questions of how to interpret the habeas statute. The next most common kind of issue last term were criminal procedure questions. The court got a ton of these, and it gets it both through direct appeals from criminal cases and from habeas cases. So we're talking like questions of ineffective assistance of counsel, questions about Miranda warnings and the sufficiency of them. Many of you will have heard of the case involving a GPS tracking device. That's a Fourth Amendment question, which is also in this group. Moving outside of the crim pro realm, there were a number of important First Amendment cases, and Professor Blocher will talk about some of them. Another big category from last term were cases involving some sort of immunity from suit. So cases involving qualified immunity, sovereign immunity. There were about 7 cases that had to do with some sort of immunity, and that's a pretty large number out of 75. And then, of course, there were a ton of important cases dealing with questions of governmental power, congressional power, executive power, and the question of preemption that Professor Young will talk about a bit. This is not exhaustive, but gives you a sense, I think, of the variety of the Supreme Court's docket. And although there were, some real blockbusters last term, the court is also doing a lot of work in the trenches of less sexy cases. So there are some pretty boring statutory interpretation cases, and the habeas cases are sometimes really tough statutory interpretation questions. And so don't ever lose sight of the fact that what the court is doing is actually very lawyerly a lot of the time. Not to equate lawyerly with boring. You understand what I mean. So as you'd expect, there were far more reversals than affirmances. There were 28 affirmances and 47 reversals, and that's consistent with the conventional wisdom that the court takes cases to reverse. Right? The thing that motivates justices to vote to grant cert is that they think what happened below was wrong. Digging a little deeper into the results, we see a pretty divided court. Although slightly less divided than average in recent years, and not always divided along the lines you might expect. 44% of the court's decisions were unanimous last term, and that was a little higher than average. At the other end of the spectrum, 20% of the court's decisions split 5-4, and that was a little below average. And so the court this term was split slightly less sharply than it has been split, but still fairly sharply, right? Only 44% were cases where all 9 agreed. Now, you probably won't be surprised to hear that the justice who was most frequently in the majority and who wrote the most majority opinions was Justice Kennedy. Justice Kennedy is typically viewed as the swing justice because he's positioned ideologically between the conservative wing of the court, and so that's Chief Justice Roberts, Justices Scalia, Thomas, and Alito, and the liberal wing of the court, and that is Justices Ginsburg, Breyer, Sotomayor, and Kagan. Given that apparent position, it makes sense that Kennedy would be in the majority most of the time, because when the conservative bloc and the liberal bloc are voting together, Justice Kennedy decides which of those blocs is going to be the majority, depending on how he casts his vote. And indeed, the most frequent voting alignments in 5-4 cases were these sort of predictable liberal 4 plus Kennedy or conservative 4 plus Kennedy. There were 15 5-4 cases, and 5 of them were the conservative 4 plus Justice Kennedy, 5 of them were the liberal 4 plus Kennedy, and the other 5 were sort of weird alignments that don't break down easily along ideological lines. So, I think that's kind of a good news, bad news piece of data. The sharpest ideological divides, the ones that you can predict most sort of cynically from the court, happened in 10 cases out of 75. And I think reasonable minds can disagree about whether that's a lot or not that many. And of those 10, they were split evenly. The liberals won 5 and the conservatives won 5. Of course, that's an incredibly rough measure of how ideological this court is, and it leaves out the healthcare cases, which split along ideological lines except slightly different ones, because we got a somewhat surprising switch from Chief Justice Roberts. But it can give you at least a sort of rough sense of what things look like up there. I mentioned that Kennedy is the justice most frequently in the majority. Justice Kennedy was in the majority in 93% of all cases, 88% of divided cases. So there is not a lot happening at the Supreme Court that does not have Kennedy's stamp of approval on it. Interestingly, Chief Justice Roberts is right behind him in that kind of stat. The Chief was in the majority in 92% of all cases and 86% of divided ones. Now, that may be an indication of how conservative this court is, because Chief Justice Roberts is typically viewed as a pretty conservative guy. Alternatively, it might suggest that the Chief is less conservative than he's generally viewed as being, or it may suggest that he's just a savvy chief. The question of who is in the majority is related, particularly for the Chief Justice, to the question of which justice writes the majority opinion. As many of you probably know, opinions get assigned authors at the justices' conference, and so the justices vote on each case. And then if the Chief Justice is in the majority, he assigns the opinion. If the Chief Justice is not in the majority, then the most senior justice in the majority gets to assign the opinion. And so in the cases that divide along the familiar ideological lines, that will usually mean that if the Chief isn't in the majority, then the opinion is assigned by Justice Ginsburg these days. Now, lots of people thought that Chief Justice Rehnquist would go out of his way to make sure he was in the majority just so he'd get to assign the opinion. And it may be that the Chief Justice Roberts is doing similar things. So if you understand things along those lines, it helps understand why you also see Justice Kennedy writing the most majority opinions. So think of yourself, you're the justice who gets to assign the majority opinion. It will often make sense for you to assign the opinion to the justice whose vote is shakiest. Because that means that justice, that swing vote, gets to make sure that the opinion says what he needs it to say in order to stay on board. If instead you assign the opinion to someone else, you run the risk that your 5th vote, that shakiest vote, might peel off and join the dissent and you lose your majority. And so this may help explain why Kennedy authored not only the most majority opinions, but also the most 5-4 opinions. If Kennedy's the swing vote, it often will make sense to give him the opinion to write. This also may help explain why Justice Scalia, who's typically far more extreme, authored the highest proportion of unanimous opinions and 0 5-4 opinions. Right? So if you're Chief Justice Roberts and you have a unanimous court, so you've got 9 votes for your result, that's a pretty safe time to assign the opinion to Justice Scalia, right? Who may say some stuff that causes other justices to peel off. Because if you've got 9, you could lose 4 and still have the majority. But if you've only got a 5-justice majority, then Justice Scalia is a more dangerous bet, and so this may explain why neither Scalia nor Thomas authored any 5-4 decisions last year. And the last thing that is interesting from looking at the data is just how many opinions these justices are churning out. And there are vast differences among them as individuals in how much opinion writing they do. So Kennedy authored 0 concurring opinions. That may be a reflection of his bargaining power. He doesn't need to concur because he can get the majority opinion to say what he wants it to say. But it may also be his personal style. They really do differ in how willing they are to just bang out an opinion. So Sotomayor wrote 7 concurring opinions. Kennedy wrote 0. Roberts wrote 0. Ditto for dissents. Scalia and Breyer each wrote 10 dissents. Kennedy wrote 2. Kagan wrote 1. So there are real big variations in the kind of style of the justices. On the whole, though, they are churning out a lot of separate opinions. So I said there were 75 merits decisions. There were 160 opinions. And a lot of the work that the court is doing these days, we can see then, is done through articulating what exactly it is that divides them. Right? It's not, they seem not to see their role as primarily resolving as many disputes as they can. Right? They're taking fewer cases than they did historically, but they're writing far more opinions. That is in part what keeps them busy. And you know, it's an interesting, I think, policy question whether that's the model of the Supreme Court we find more attractive, or whether we would like them saying less individually and just resolving more cases. I will stop there before Neil sanctions me. So
Consider yourself sanctioned. Professor Young.
That was really helpful.
thanks,
Thank you. I'm just going to talk about cases. And I'm going to start with Arizona versus United States, which probably feels cheated as a case, because it would have been the blockbuster case in any other year, but for the case which shall not be named. The name of the case may signify a new era in constitutional law. I think it's fair to say that Arizona has come to symbolize kind of the oppositional positions on a lot of issues, and there's been a lot of conflict between the federal government and Arizona on a number of issues over the past year or two. And all I can say about that is I think there's a lot of people in Alabama and Texas that are really grateful for that. The other thing I'll say by way of introduction is that I've done a lot of work on preemption law for a long time, and this is the first time that a preemption case has ever been considered one of the sexy cases of the term, so yay. People are kind of fuzzy about what the law in Arizona did. It's called SB 1070, and 4 provisions of it were at issue in this case. Section 3 made failure to comply with federal alien registration requirements a state misdemeanor, so they're just criminalizing again under state law. Section 5 made it a misdemeanor for an unauthorized alien to seek out or engage in work within the state. Section 6 authorized state officers to arrest without a warrant any person the officer had probable cause to believe had committed a removable offense, an offense that would make them removable from the country under federal law. And then finally, Section 2B required state officers who were already stopping, detaining, or arresting people for other reasons, like a traffic stop or something like that, to verify that person's immigration status with the feds. A bunch of other states have passed similar laws, and the United States sued to enjoin SB 1070 from ever taking effect, which they were successful in doing. So this law has never actually gone into effect. Now, a lot of the public rhetoric about this law and about Arizona's policy in general has focused on questions of equality, racial profiling, things that might be a problem under the various criminal procedure provisions in the Bill of Rights or maybe the Equal Protection Clause. That's not what the case was about. The government sued under the Supremacy Clause, arguing that the statute was preempted under federal immigration law. And the court strikes down Sections 3, 5, and 6 as preempted under those laws. They rejected what's called a facial challenge to Section 2B. Now, by facial challenge, what we mean is an argument that the law could never be applied constitutionally. It's hopeless. There's no situation in which this law can be applied in a constitutional way, which means that the law is invalid across the board. Ordinarily, people challenge laws as applied to them. You say that this law was unconstitutional as applied to me. Imagine, for instance, a trespassing statute that ordinarily is perfectly constitutional. You can't trespass on people's land. On the other hand, if it's used to discriminate against speakers taking a particular cause, for instance, then that might be unconstitutional as applied to them. And so the court says that the last provision, Section 2B, is not unconstitutional on its face. It might be constitutional to check people's immigration status in connection with a stop in some circumstances. But they opine that it might very well be that the law is unconstitutional as applied in certain situations. So let me just go into a little more detail. The court, the majority opinion written by Justice Kennedy, but also joined by Chief Justice Roberts, as well as the liberals, applies pretty much straightforward principles of federal preemption law. On Section 3, the court said that the federal law had occupied the field, which means left no room for state regulation of alien registration. So no matter what the state law did, even if it mirrored the federal law, that was unconstitutional under the Supremacy Clause because Congress had left no room for any state regulation, only federal regulation on the question of alien registration. Section 5, on the other hand, which was it's a misdemeanor to apply for work, went down on conflict preemption grounds, which means that the court said that there may be room for state regulation of the employment relationship, even for unauthorized aliens. In fact, the court had upheld Arizona regulations of employment of unauthorized aliens last term in a case called Whiting under a different statutory provision, but this particular aspect of Arizona law, which made it a crime for the individual alien to seek work, was in conflict with the federal statute. That's because Congress had made a pretty deliberate choice to go after employers who hire illegal aliens rather than the aliens who are seeking work on their own. Section 6, which was the option to arrest on probable cause of a removable offense, that went down on obstacle preemption. And basically, the court said that federal enforcement discretion, Congress thought that it was important that the feds be the ones who enforce this aspect of federal law and that their discretion should control. And so if you add a whole nother layer of state enforcement with state enforcement officers making their own prosecutorial discretion decisions, that would be in conflict with Congress's policy. And then finally, the 2B question, as I said, it was not unconstitutional on its face. It could be unconstitutional in the future if, for instance, they hold you too long in making this check of your immigration status. That might be tantamount to holding you on suspicion of an immigration violation, which they're not supposed to do. And so the court practically invited as-applied challenges to that statute. So let me just make a couple of comments about this. First of all, I think there's been a lot of disagreement about who won here, and I think that's not that hard a question. This is a pretty solid victory for the Obama administration. 3 of the 4 provisions were struck down, and the 4th might well be in the future as these as-applied challenges come to the court. Second, I think the court comes dangerously close to saying that the enforcement decisions of the executive branch deciding what federal crimes to prosecute and what federal crimes not to themselves have the force of federal law. So for instance, if the executive decides as a matter of policy not to prosecute certain offenses, that itself has preemptive effect. And that would be a surprise to anyone who's read the Supremacy Clause, which seems to say that the only things that amount to supreme federal law under the Constitution are the Constitution itself, treaties, and actual statutes. But I doubt that the court is going to extend that idea much outside the immigration context. I think that's one of the ways in which immigration is likely to be considered special. There are 2 silver linings from my perspective. One is that notwithstanding some broad language about Congress's primary authority over immigration, the court basically decided this case under ordinary preemption principles. The Ninth Circuit, on the other hand, had relied very heavily on the idea that immigration is this exclusively federal field and the states just can't mess with it at all. Right? And that harkens back to a day when the court used to decide federalism cases generally by saying that there are some fields that are exclusively federal and some that are exclusively state, and never the twain shall meet. That really hasn't been the law since 1937, and so it's good that the court shied away from that. In a globalized world, for instance, just about everything the state regulates is going to have some connection to foreign affairs and things like immigration. All right, and then finally, the dissents by Justice Scalia, Thomas, and particularly Alito included some of the strongest anti-preemption language that we've ever seen from them, and that may be important in future preemption cases. On the other hand, I think it's fair to say that immigration makes everybody crazy, and so I wouldn't generalize a whole lot from this case. So let me talk a little bit about Hosanna Tabor, which I do think is the biggest religion case in quite a long while. Hosanna Tabor is a congregation of the Missouri Synod of the Lutheran Church. It also operates a school. The school includes a subset of teachers who are called teachers. They're called to their vocation by God, and they're commissioned as ministers by the church. So Cheryl Parrish was a called teacher of kindergarten and 4th grade at the school. She developed narcolepsy, which interfered with her teaching. It's okay for y'all in the audience to have to sleep during class, but not for the teacher. The church puts her on leave. When she's ready to come back, the church tells her they've filled her position. She threatens to sue, and the church says they were rescinding her call because one of their core beliefs is that they resolve all their differences internally without resorting to litigation. And so she had violated the religious beliefs of the church by threatening litigation. So Parrish files a charge with the EEOC under the American Americans with Disabilities Act. The EEOC sues the church on her behalf, and the question in the case was whether the church was shielded by something called the ministerial exception, that statutes like the ADA and other kinds of federal laws cannot apply to the ministerial staff of the church. And the EEOC took the position that there was no such thing as a ministerial exception. The court, Chief Justice Roberts' writing, unanimously holds that, yes, Virginia, there is a ministerial exception, and it bars the EEOC's suit here. They survey a lot of history and precedent, and they conclude that requiring a church to accept or retain an unwanted minister or punishing a church for failing to do so interferes with the internal governance of the church, depriving the church of control over the selection of those who will personify its beliefs. That violates both the free exercise and the Establishment Clause, which is an accomplishment. They weren't very impressed with the EEOC's position, which had categorically rejected the idea that there was any such thing as an exception for ministerial personnel. The Obama administration had argued that the religion clauses were simply irrelevant to cases like this, and that the only thing that would shield the church would be something like freedom of association, which didn't work here. And the court said, we cannot accept the remarkable view that the religion clauses have nothing to say about a religious organization's freedom to select its own ministers. So, just a couple of comments here. This one's a pretty big slap for the administration. A lot of academics have recently taken the position that the religion clauses are really just equality clauses. There's nothing constitutionally special about religious belief. The Obama administration is the first administration ever to adopt that position. I think it's fair to say that this is the most anti-religious position taken by the U.S. government since the United States went after the Mormons in the 19th century. Right? And frankly, the administration got bench slapped on that position in this case, 9-0. And let's hope that's the end of that position. There are difficult questions ahead, however, and they're signified in the concurrences. So, for instance, Justice Alito and Kagan write an interesting opinion worrying about what counts as a minister and what do we do with religions that don't have ministers, they call them something else. Justice Thomas writes a concurrence about, do you have to defer to the church's view of who's a minister or who's not? Maybe you should, maybe you shouldn't. So I think there's a lot of harder issues coming, but the basic question of whether there's such an exception was easy, and the court, in a remarkable display of unity, says that it does exist.
Thank you, Professor Young. Professor Bartlett.
So I'm going to start back to put my case, Coleman versus Maryland Court of Appeals, in context with a 2003 decision called Nevada Department of Human Resources versus Hibbs, which held that states can be made to pay damages for violations of the family care provisions of the Family and Medical Leave Act of 1993, otherwise referred to as FMLA. This act required employers, including states, to provide up to 12 weeks of unpaid leave to eligible workers when leave is necessary to care for a new child or a family member. The significance of the case is that damages are ordinarily not allowed against states because of the doctrine of sovereign immunity, which is persons can only get damage relief against states if the state itself or if Congress, acting under its powers under Section 5 of the 14th Amendment, abrogates that immunity. This is a pretty complicated doctrine, and you'll let professors, actually any professor here, could teach you about it in their respective courses. I'm not going to really get into too much detail about it, but for present purposes, it's clear that Congress properly abrogates state sovereign immunity when it is responding to a pattern of state constitutional violations, which could include sex discrimination, with measures that are congruent and proportional to the violation. Now, in Hibbs, the court held that there was ample evidence in the legislative history of discrimination against women in the workplace based upon stereotypes about women as caretakers. Employers assumed that new mothers were not serious members of the workforce. They couldn't be relied upon to return to work. If they did, they'd be so loaded down with family responsibilities as to be less productive. These were a sort of series of descriptive stereotypes. And then there was the normative stereotype that mothers really didn't belong in the workplace. They should be home with their children, etc. So all of the evidence of the operation of these stereotypes, according to the court in Hibbs, presented a well-documented pattern of sex-based discrimination in family leave policies and thus justified Congress's action, which included damages against employers, including states, when they violated these provisions. Last term, there was a kind of follow-on case to Hibbs called Coleman versus Maryland Court of Appeals, in which the court, in a 5-4 decision, again written by Justice Kennedy, held that the same evidentiary base that established, that gave Congress grounds to abrogate state sovereign immunity in the family care provisions did not exist with respect to the FMLA provisions providing for leave for one's own illness, the so-called self-care provisions. Kennedy's opinion concluded that the self-care provision revealed a concern not about sex discrimination, but about the economic burdens on the employee and the employee's family when a worker got sick. So it's about illness, not about sex. True, the self-care provisions did protect women who were pregnant as well as workers with other disabilities, but the court found that the concern about the evidence of discrimination in this regard was not congruent or proportional to any identified pattern of state constitutional violations. Now, the dissenting opinion by Justice Ginsburg took the position that the FMLA was directed in its entirety against gender stereotyping in the workplace, and that the self-care provisions and the family care provisions worked together to serve the goal of ending the sex discrimination that had been established in the legislative history. According to Ginsburg's reading of the legislative history, Congress understood the need to protect both pregnant women with respect to their maternity-related disabilities and women with respect to their family care duties. She cites several examples in the record. It would make scant sense to provide job-protected leave for a woman to care for a newborn, but not her own recovery from delivery, a miscarriage, or the birth of a stillborn child, she writes. So in other words, I didn't read that sentence right, but it doesn't make any sense to protect her when she's engaging in family care for a newborn, and not protect her with respect to the disabilities that attend her pregnancy. And her reasoning is not unlike, I didn't actually realize we weren't going to be discussing the Affordable Care Act today, but it's not unlike some of the defense in that act that the individual, the so-called individual mandate was necessary in order to make other laws work. Ginsburg is arguing in this case that the self-care provisions were really necessary to make the rest of the act work. So what interests me about this case is the window it provides on the issue of pregnancy in the Supreme Court. For those of you who have not had con law, which I suspect is probably a majority of you in this room, it may surprise you to know that as a matter of constitutional law, the court ruled in Geduldig versus Ayala that discrimination against a woman because of her pregnancy is not discrimination based on sex. Now, Congress overruled that with respect to Title VII and employment discrimination, but as a matter of constitutional law, it is still the case that pregnancy discrimination is not sex discrimination. Congress acted with an act called the Pregnancy Discrimination Act, which said, yes, it is in the workplace. And women's advocates since then, in a debate that occupies a good part of Justice Ginsburg's opinion in this case, were split about how best to eliminate the work disadvantages that women face as a result of pregnancy and childcare, even including how to interpret the Pregnancy Discrimination Act. The debate was between advocates who urged that there should be special workplace protections for pregnant women and maternity-related disabilities, and those who felt that the measures should be gender neutral. The Supreme Court in 1987 upheld, under the Pregnancy Discrimination Act, a California statute which required employers to give pregnancy leaves for pregnancy, but not for any other disability. So that seemed to at least okay the approach of taking measures that were sex-specific, that would only benefit women. But a lot of advocates believed then and since then that special protections for pregnant women or women who have had children only reinforce stereotypes associated with women with pregnancy and with child-rearing, and that a gender-neutral approach is the best way to go to break down these stereotypes. And these stereotypes are the real barrier to women in the workplace. The idea was that men using such leaves would reduce the stigma of taking a family leave. It would reduce gendered stereotypes about workplace commitment, and it would reduce the disincentives of hiring women that special women-centered provisions would seem to create. Ultimately, this sex-neutral approach has been the one that's prevailed in most jurisdictions, and it's the approach that Congress took in the FMLA. And one of the reasons I've gone back to this history, and one of the reasons it's very significant and interesting, is that the plaintiff in Coleman, a fact that I haven't told you yet, and that really the court doesn't make much of in the decision itself, the plaintiff was a man. He hadn't just delivered a child, he had some other disability, and the state denied him a leave when he was otherwise entitled to it, and those are the underlying facts of the case. There is a long history of Supreme Court cases finding that explicit sex discrimination in the law is unconstitutional, whether it disadvantages men or women. So there's been a gender-neutral approach against sex discriminations. Here, though, the plurality opinion in Coleman does not appear to recognize the importance of gender neutrality with respect to the self-care provisions and how these gender-neutral self-care provisions interact with the family care provisions, which Ginsburg addressed it in detail, how they all came together to create the pattern of state constitutional violations that were described in the record. So I think in failing to do so, this decision is a backward step in this long history, which I've only given you a part of kind of back and forth recognition about pregnancy and child rearing as really the main source, a very intractable form of sex discrimination. To close and to be really clear, this decision does not change the substance of the law in terms of it's still illegal for employers to deny leaves that they're otherwise entitled to under this act. They just can't get damages. So in terms of the effectiveness of the act as to state employers, it's far less effective. I'll just say in closing that I do think that Chief Justice Rehnquist, who wrote the opinion in the Hibbs case, were still on the court, it would have had a different result.
Thank you, Professor Bartlett. And now we'll hear from Professor Blocher, who will talk about the First Amendment in speech.
I will do my best. The court had a lot of big free speech cases on the docket last year. I'm going to focus particularly on one for reasons that will become evident. And in the process, I'll try to say something about some big themes, which I think it illustrates. One of those themes, just at the outset, is that the Roberts Court has shown a particular interest in free speech cases. There have been a lot of big ones in the last few years, just since 2010, some of which you may have heard of. Citizens United was a big First Amendment case on corporate spending. There was a case called Snyder v. Phelps about the Westboro Baptist Church protesting at funerals, a case called Brown about violent video games, a case called Stevens about animal cruelty videos. And in almost all these cases, the court has proven to be very protective of free speech claims. In other words, striking down regulations on speech. This past term had the potential to be another big one. I'm going to focus on one case in part because the three other potential big cases didn't materialize the way I think people expected, or maybe did expect. One is a case called Bullock, in which the court actually declined to reconsider Citizens United. I'm happy to talk about that one in questions, but the court actually declined cert on it. People thought that might end up being a big one. In another case, an unrelated case called Knox, the court made it a little bit harder for unions to get dues out of non-union members working in union shops. This was a big case for those of you interested in labor law. I'm happy to talk about that in questions too. And then third, another case you may have heard of, or certainly heard the underlying facts of, a case called FCC v. Fox, which involves the fleeting expletives, which things that may happen, for example, during Super Bowl halftime shows, or when Paris Hilton gets near a microphone. These are things that broadcasters had been prosecuted for or been warned for by the FCC. The court transformed that into a due process case and resolved it on those grounds, so we didn't have a First Amendment holding there either. We did, however, get United States versus Alvarez, which is a great case, particularly in an election year. So I'm going to focus on that one. A second theme, I'm not sure if this is a theme or as much as an inside joke, but you guys are inside now, so you should know it, is that people often make fun of, we talked a lot about Justice Kennedy, people often make fun of the way he writes. Even people who agree with him, cases like Lawrence v. Texas, a lot of people celebrate the result, but make fun sometimes of the way he writes. He wrote the plurality opinion in Alvarez, and I have to say that the opening of it is truly fantastic, and I genuinely mean that. I'm just going to read the first few lines because it sets the stage better than I could do. This is the opening. Lying was his habit. That is the first sentence of a Supreme Court opinion. It's just fantastic. It's like a novel. Lying was his habit. Javier Alvarez, the respondent here, lied when he said he had played hockey for the Detroit Red Wings and that he once married a starlet from Mexico. But when he lied in announcing he held the Congressional Medal of Honor, respondent ventured onto new ground. For that lie violates a federal criminal statute, the Stolen Valor Act of 2005. In 2007, respondent attended his first public meeting as a board member of the Three Valley Water District Board. He introduced himself as follows. I'm a retired Marine of 25 years. I retired in the year 2001. Back in 1987, I was awarded the Congressional Medal of Honor. I got wounded many times by the same guy. None of this was true. Now, I have to admit, I do not know anything about the Three Valley Water District Board, but I'm a little confused as to why combat experience would potentially be necessary for the work of the board. But I have seen the movie Chinatown, which I recommend if you haven't seen it. And this case comes from Southern California, as that movie does. Shows that water politics maybe get pretty rough. The First Amendment question here, back on track, is whether Congress can make it a crime to lie about having received military medals. And the four-justice plurality, the one Justice Kennedy authored, joined there by Chief Justice Roberts and also by Justices Ginsburg and Sotomayor, said no. Justice Breyer, joined by Justice Kagan, concurred and said no. In other words, you can't make this criminal for slightly different reasons. And then the dissent by Justice Alito, joined by Justices Scalia and Thomas, said yes, you can make this criminal. And that leads us to the third theme, which I think this case illustrates, which is the difference between, as an ongoing debate, a difference between what people sometimes call categorical and balancing approaches to constitutional or any other kind of law. You'll sometimes hear this referred to as a rules standards debate. Something's going to pop up in a lot of your classes over the years. I'm guessing a lot of you or one else. Those of you who've already been through classes, you've seen this already. And I think it explains the difference between the plurality and the concurring opinions here. They agree on the result, but not on how they get there. The plurality starts by saying this is a case about whether to carve something out from First Amendment coverage. In other words, whether to deny coverage to false statements, specifically false statements about military medals. And they say that the only way you can get there, the only way you can prove a carve-out from the First Amendment, which is what the government, at least on one level, wanted to do, is to have, and this is a quote from a previous case, the violent video games case, in fact, persuasive evidence that a novel restriction on content is part of a long, if heretofore unrecognized, tradition of proscription. So in other words, you can't just come up to the court and say, hey, look, this is really bad speech, it's really hurting a lot of people, we need to be able to ban it. You have to be able to show there's a tradition of doing that over time. You can query whether the tradition itself might be based on some kind of balancing of the interests, but the reasoning has got to be based on some sort of traditional, historical and traditional, in fact, as the court says, reasoning. The plurality finds none. We do not have a tradition of banning all kinds of false speech, just some kinds of false speech, and this is not one of them. Justice Breyer, joined by Justice Kagan, gets to the same conclusion that this is covered by the First Amendment, but by a different route. And Justice Breyer, you guys may know, he likes to just kind of throw it all in the pot, stir it around. He gets like a all things considered kind of reasoning. He calls it proportional review. Some people call it intermediate scrutiny. Some people call it balancing. He says, right at the outset, I do not rest my conclusion upon a strict categorical analysis. He says you should look instead to the specific harms caused by this speech, the justifications for regulating it, and the potential alternatives. And he says, look, based on all that, not based on the tradition, but based on all that, I can conclude that this is covered and can't be banned. The dissent doesn't really take sides on that categorical balancing approach. They do sort of employ elements of both. They say, as a general matter, this is a quote, as a general matter, false factual statements possess no intrinsic First Amendment value, and that this particular statute, and this becomes important, reaches only a very specific kind of lie, which is actually pretty easy to prove. You know, you either did or didn't get the medal. This isn't like, you know, are you a Christian or are you not? This is something sometimes people debate, right? I'll talk about that in a minute. This statute reads only knowingly false statements about hard facts directly within a speaker's personal knowledge. Therefore, we don't have to worry about it chilling other potentially valuable free speech. Also, the dissent says we've got a long tradition of trying to protect our medals from being I guess you could say tarnished by people falsely claiming to have received them, kind of akin to a trademark analysis, those of you who've done intellectual property or are interested in that. All of the opinions, though, are based on a final theme. This would be my fourth and sort of final theme here, which is a faith, I think, in the marketplace of ideas. The idea is that as long as, if people are they're saying wrong things, they're saying dumb things, they're saying false things, the cure is more speech, not government regulation. This guy, Alvarez, lied. He got caught, right? You know, his political career is going to be over. And the justices say because of that alternative, we don't have to have the government step in to correct things. And I just want to suggest that that's actually a hard question. That's a bit of an empirical assumption. That's a provable, disprovable thing. It's based on an assumption about how political discourse works, a factual one, not just a sort of an emotional attachment. And there may be some reason to question whether it actually works. There's a lot of, those of you who've done behavioral economics or who've done cognitive psychology, you know there's a lot of studies, especially in the recent years, saying that people tend to assimilate facts that confirm their worldview, and they tend to just push to the side things that don't. And it's not always clear that political discourse is going to catch them. In fact, there's some reason, I think, that political discourse might make it worse. That just puts facts out there that are already charged and people can sort as they want. You guys can pick your own examples. There are plenty of them. I'll just highlight a couple. The noted scholar of biology and Republican congressional candidate Todd Akin this week said, this is a quote, "If it's a legitimate rape, the female body has ways to try to shut that whole thing down." Now, I say this not just to take shots at Representative Akin, but to suggest this is not just jaw-droppingly wrong-headed, it's just wrong. This is just a factual matter. You know, maybe this is good evidence that the court was right because it made national news. And a lot of people jumped down on Representative Akin. Maybe he will not win the election. Nobody knows. There are other things that get a little bit harder, though. People can say, oh, it's easy to cut facts, you know, cut falsehoods out of political discourse. Consider a few more. I've just picked one from each from the Romney and Obama campaigns. Mitt Romney's repeatedly claimed to have created as many as 100,000 jobs while at Bain, but he hasn't presented any evidence of that, and there's some suggestion that those 100,000, many of them came after he left the company. It doesn't include the jobs that were lost when he shut down companies, right? Is that a falsehood? It's a little harder to say. The Obama campaign has claimed in an ad that when Romney was governor, Massachusetts, quote, fell to 47th in job creation. That leaves out the fact that they were 50th when he took over as governor, and was 28th when he left. So it was 47th over the period, but fell makes it sound like a little bit of a lie. To get back to the opening line of Alvarez, and then I will close, I think it's not too much to say that lying or falsehood, at least, or pushing the bounds of the truth is the habit of people this time of year, politicians this time of year, and it's scary to think about the scope of that, but it might also be scary to think about the government punishing people for engaging in this kind of speech. What would it look like for Mitt Romney or Todd Akin to get arrested or fined for saying something like that, or the president himself, for that matter? That might be kind of scary. I just raised the question to say this is a hard issue. We may see cases like this down the road.
Well, thank you, Professor Blocher. And after today's event, please do feel free to ask Professor Blocher about all of his medals. We have 11 minutes, and I have questions for all of our panelists, and I will ask none of them. Let me turn to you folks. Questions, comments about anything we've heard or anything else on your mind of general pertinence to the Supreme Court's October 2011 term. Yes.
Do you see any trend of the court overturning specific circuits more than others? For example, the federal circuit's been getting crushed a lot lately. Do you see that continuing? Does that affect cert petitions or, you know, grant rates? Anyone who wants to talk about that?
You know, I can tell you in this term, the Ninth Circuit is a real outlier, and that's not uncommon. The Sixth Circuit sometimes gets smacked down a lot. When I clerked for Justice Stevens, and at the time he was sort of in charge of the Sixth Circuit, and whenever he would bring that up, he would sort of just hang his head because the Sixth Circuit was just notorious as a circuit that was dysfunctional. And so I'm not sure about historical trends, and if anyone on the panel knows, please feel free to speak up. But there are certainly some circuits that the Supreme Court seems to have its eye on a little bit more, and to me, the Ninth Circuit is the one that jumps out. The Fed Circuit is a different example, although you're absolutely right, and you do see trends in the court's decision-making as it seems like the court has gotten interested in X, and so the court may be really interested in free speech, and they have gotten interested in patents in the way they weren't for years and years, but all of a sudden they've said, hey, we can do this, and they've gotten a taste for it.
Just so we're all on the same page, below the U.S. Supreme Court are the federal courts of appeals, and there are 13 circuits. 11 numbered circuits, 1 through 11. Then there's the Federal Circuit and the Court of Appeals for the District of Columbia. And the question is whether there are particular circuits that seem to get reversed more by the Supreme Court than others. And I think the answer is yes. And Professor Lemos identified which ones they were. Other questions? Well, let me, yes.
Yeah, so I was wondering if any of you would like to say a word or two about the Zivotofsky case. So Chief Justice Roberts seemed to say pretty clearly that domestic foreign affairs power is justiciable. So I was wondering if this case, that non-opinion system might be coming back in court, will affect how the political question doctrine is taught and understood.
You want to speak to that? No?
Yeah, not a bit.
Not a bit. Yeah, this is about the Jerusalem passport case. Yeah, and I can talk and pretend like I know what I'm talking about, but the truth is I haven't studied it and I couldn't give you an informed answer.
It's probably worth saying political question doctrine if people haven't gotten there. There are some cases courts just won't look at. They say, oh, this is not for us, this is not for our jurisdiction. This is well established since the beginning of the Supreme Court's consideration of dockets. Zivotofsky raises this very difficult question again about what is it that the courts are capable of doing in the first place. You guys may be covering this in con law. You certainly cover it in Fed courts or in Civ Pro at some point.
Other questions? All right, we have some time, so let me ask Professor Young about Hosanna Tabor, right? And I'm wondering how would the court distinguish, or would it want to distinguish, or would you want it to distinguish some other scenarios, right? So what about a priest who's fired by his church for reporting child sex abuse by another priest at that church to the police? Is that also within the scope of the ministerial exception? And I saw some justices in the opinion say, well, that's not this case, that's some other case, right? But what's the limiting principle that we're going to hear so much about when we talk about healthcare?
Yeah, I don't mean to, when I say the case is easy, it's not intrinsically easy, it's more easy because of the way in which it was litigated, I think. So Susanna Sherry has an article in this year's Supreme Court review talking about last term's class action cases, but it could also apply to this case as well. And the title of it is Pigs Get Slaughtered. And people who take extreme positions tend to lose, and tend to lose badly, and they lose in ways that often cover up the things that actually a more modest version of their position would have had going for it. And so I think the reason why people thought this case was going to be hard was that the ministerial exception question is hard, right? Is it really from all laws? And does it really cover all dismissals for anything that could be construed as a religious reason? Because in a way, this case has awful facts if you're in favor of the ministerial exception. So it's easy to say, you shouldn't be able to regulate when the church fires somebody over a question of internal church doctrine, right? I mean, if you've got a Reformed Jewish president and there's a Orthodox congregation that's getting it wrong, and you start prosecuting them for disagreements about doctrine, but the religious reason here was we don't litigate. Right, and the common term for that is retaliatory firing,
Exactly.
right? I mean, you're not supposed to be able to fire people for filing a complaint with the EEOC. And then for the church to be able to just say, well, we're religiously against filing a complaint with the EEOC is like saying we have a religious belief against federal law, right? And so I do think this would have been much, much more difficult if the administration had taken a more nuanced position and said, well, that's not a good reason. But in the posture in which it comes to the court, the question is there an exception at all? And the court says, of course there is, and we'll worry about where it's going to be. And I think if you see the concurrences, if you put the concurrences together, for instance, it's going to make the line drawing really, really hard, right? So Kagan and Alito say it can't just be things that are called ministers, and that's clearly got to be right. It could be all kinds of religious duties. And Thomas says you can't second guess the reasoning of the church about who's a minister. If they say it's a minister, you got to take their word for it. And that seems right too. But now put those things together, and the church can say anything is a minister, right? And you'll have to defer to them. And it's not clear that will work as a way to run the exception.
No, yeah, please.
Can I add to that? So, the concurring opinion, we're kind of focused on how do you determine who's the minister, but your earlier comment, there are a number of sex discrimination sex harassment cases previous to this decided at a lower level, in which it seemed like they were working on a pretty sensible line, which was where it has anything to do with church doctrine, that's one thing, ministerial exception may apply, leaving aside who's a minister and whether the janitor is a minister or just the teachers. But where it's complete, where the church doesn't have a plausible case that this is part of their religious doctrine, and of course there are entanglement issues here, but and sexual harassment was kind of the quintessential example of that. There's no church that says we have to harass our employees or else our as part of our religion. Then it's not that the person's not a minister, it's that this exception doesn't apply. Right. It seemed to me they were working up something fairly sensible there for a while.
I think the problem is the court in other areas have been completely unwilling to inquire into what counts as religion. I mean, I have some former students who got married and they wanted their friend to marry them, and he had to get certified as a minister by sending in this form that he found in the back of a comic book and got ordained as a minister in that church, and he married them. And that would work under current free exercise doctrine, because the court is completely unwilling to inquire to what counts as a religious belief, what counts as religious doctrine. And I agree, I think that's a very sensible line, but you have to get into that, because the church, you'll find a church that will say, our view is the men have dominion over the women, and so harassment is one of the rights that they have, and therefore this was a religious disagreement.
I also think that it's, as Professor Young indicates, the difficulty here is the church is not saying that, right, getting rid of priests who are suffering from narcolepsy, right, is part of our doctrine, is we don't litigate. We deal with these things internally, right? So I know the head of a religious school who was fired for sexually harassing the teachers at the school, right? Now, if the claim is we don't litigate these matters, we deal with them internally, and so we're going to fire you if you know about this and report it to the EEOC or the police, right? That seems to me to raise a difficult question. If you're saying I don't think you're going to have anywhere near a majority of this court that is going to decide this case this way if we're talking about retaliation for reporting sexual abuse of children. And I think it tells you something about limiting principles and how the court deals with it. That is a difficult case. The court distinguishes that case. I think the court got this case right and appropriately distinguishes that one, but the court doesn't tell us what the limiting principle on the ministerial exception is. Imposing limiting principles appropriately requires judgment, and it requires a distinction between real threats to constitutional values and mere shadow. And this is exactly going to be part and parcel of the debate over the minimum coverage provision in the Affordable Care Act. Is this an appropriate imposition of limiting principles on Congress, or is this creating hypotheticals that are very unrealistic and the court's insisting on them to strike certain stuff down, whereas in other areas of the law, they're not that demanding of the legislature or of a doctrine of their own creation?
It is a really interesting case, though, in terms of just the earlier point of the importance of the way that a case is lawyered.
Yes,
It
absolutely.
seemed to make all the difference in this case.
No, I think it's a very good
That's why we all want you to.
Yes, Phil.
Going on a more broad note,
especially prior to the ACA case, this court was, or this term was painted as being particularly polarizing, particularly political, and a number of people, including Professor Carrington, came up with ideas for reform of the Supreme Court. I'm wondering, do any of you see this term as being particularly divisive or illegitimate, and whether or not any of you see a need to reform the Supreme Court?
Yeah, I would agree that that's pretty broad. That's pretty general. That's pretty broad. Anyone want to take that on?
They should clearly put more academics on it. I think that's in some ways a dog that didn't bark. I mean, think about the ACA case, which was just the most elaborately pre-gamed case I've ever seen. Oh, the court's going to strike this down, and that's going to prove how political they are. Well, not so much. The most important part of the case, on the individual mandate part, you have the chief switching. The most important part of the case, functionally, I think, is the spending part, which is 7-2. Which is really interesting. It's the first time that Breyer, and well, Kagan hasn't been there very long, but Breyer has ever joined one of these Federalist Revival opinions, and it's a very significant holding. So that, I would not say, was anywhere near as politicized as people thought. United States versus Arizona, I mean, it's 6-3, it's not 5-4. And there's a fair amount of agreement on basic principles, even among the opinions. I think, Hosanna Tabor, which had the potential to be really divisive, and religion cases have been extremely divisive on this court. 9-zip, right? So I don't think the court is as politicized as we might worry.
Yeah, I think if your argument is we should reform it just because it's excessively politicized and its legitimacy is imperiled, I don't think this term is a great example of that. I think there are some other cases from other terms. You've got Arizona and the ACA case. You've got bipartisan, relatively nationalist majorities, right, of the court. Coming down on the same page in terms of but you could still think the court ought to be reformed. You could still think that there ought to be term limits like every other constitutional court around the world, and that has a lot to do with the trade-off between independence and accountability, and how much power and discretion do the justices have, and how long are they living, and does it make sense for a political process that produced a justice 40 years ago to still be governing the present, right? I think you can have views about that one way or another that are independent of one's views about politicization or legitimacy. Okay, we are out of time. I want to thank our panelists, and I want to thank you folks as well.
Produced by Duke University, online at duke.edu.